Hi, I'm Stan Muller, this is CrashCourse, and today we begin our mini-series on intellectual property. Hey, isn't the entire concept of intellectual property illegitimate? I mean, how can we justify locking up the world's science and art so that corporations, publishing houses, and other gatekeepers can control what we know and what we think? Information wants to be free, man. Hey, me from the past! There's a Stan from the past! This is great! Anyway, I can tell by looking into your vacant and bloodshot eyes that you've been up all night downloading Chumbawamba records over a dial-up connection. I remember those days, and I remember you desperately trying to cling to any ethos that justified your rampant copyright infringement. That is, if you ever participated in such activities. And even if you had participated in said infringing activities, the statute of limitations is likely run out. I don't even know what LimeWire is. I like how this is getting started because Stan from the past raises some interesting points. There's a good chance that he and a lot of you watching this video might think about aspects of intellectual property as outdated and pretty much irrelevant. Maybe lots of you don't think of it at all. That line, information wants to be free, has been used to argue that current intellectual property laws are outdated, overbroad, and generally awful. The quotation is attributed to Stuart Brand, and he said this to a group of computer programmers in 1984. On the one hand, information wants to be expensive because it's so valuable. The right information in the right place just changes your life. On the other hand, information wants to be free because the cost of getting it out is getting lower and lower all the time. So you have these two fighting against each other. The full quote, which you hardly ever hear, actually spells out the major tension between intellectual property and technology quite well. And it did it more than 30 years ago, when the digital age was just beginning. As information technology becomes more and more pervasive and important in our day-to-day lives in the information society, information itself becomes exponentially more important and more valuable. Paradoxically, as our information technology improves, and as our computers and connections get better and faster, and sharing becomes easier, we're less able to control the copying and dissemination of this incredibly valuable information. The law of supply and demand pushes down the information's value. This tension is nothing new. Technology, especially in the context of copyright law, has always presented challenges. Socrates, in Plato's Phaedrus, bemoaned the advent of books, arguing that they will implant forgetfulness in human beings' souls. They will cease to exercise memory because they rely on that which is written, calling things to remembrance no longer from within themselves, but by means of external marks. One way that humans have attempted to deal with these new technologies with varying success is by passing laws. The scourge of the piano roll was contemplated in the 1909 Copyright Act, the photocopier in 1976, and the internet was covered in the 1998 Digital Millennium Copyright Act. But we're going to try to avoid the simplified intellectual property versus technology binary. The idea that we have to choose between devaluing the fruits of intellectual talent and labor or devaluing the revolutionary information sharing capacity of our networks is wrong-headed. The more interesting and more difficult question is how we can strike a balance, how we can incentivize and promote this revolution in the way we share information, while at the same time incentivizing and promoting the production of creative works and inventions by having respect for the human beings that actually created them. The difference between today's debates and those that took place 100 years ago is that intellectual property pervades our lives more and more every day. This is especially true for anyone viewing this video. I know that about 90% of you view CrashCourse in a web browser, so consider the layers of IP in this very YouTube page. A lot of what you're looking at is covered by copyright. This video, for example, is covered as a motion picture work. The website itself is considered a literary work. The thought bubble, the theme song, and the video you watched right before this one all have copyright protection. The software that streams the video is also a literary work. The web browser you're using is most likely registered as a computer program, as is the operating system. Lest you Linux weirdos think that you don't have a copyright on your OS, you do. You're just not enforcing it. Even your comments could be covered by copyright. That haiku you just posted, who is this person? What happened to Mr. Green? Dislike. Unsubscribe. That's copyrightable. When you agreed to this, you granted YouTube a worldwide, perpetual, non-exclusive license to use your content in any way they see fit. There are also patents in play here. There's proprietary video streaming technology, and many of the components in your computer are patented. But wait, there's more! YouTube is a registered trademark, and if you saw an ad before this video, there was most likely a trademark in there. This is a trademark, and under this sticker is an image of a piece of fruit, also a trademark. And behind the camera, our most precious and valuable mark, Mark Olson. Mark Olson, everybody. The search algorithm that got you here, that's a trade secret. My appearance in this video and subsequent marketing of commemorative mugs with my likeness fixed on each one, that implicates my right of publicity. If you're watching this on an iPhone or an Android, there's a whole other world of copyrights and patents that apply. When you start to deconstruct it like this, it's dizzying. But despite all this complexity, most of the time the system moves along with a fluidity that sometimes makes it easy to put it out of your mind, kind of like the internal functioning of your digestive tract. But it's there, always there, gurgling and churning and functioning. Did anybody order lunch? Now, much of this fluidity and seamlessness is born on the back of hundreds or thousands of lawsuits, many of them against Google, thousands of pages of intricately complex contracts, and hundreds of millions of takedown notices. The point is that none of us, or very few of us, can go about our daily lives without being impacted by intellectual property. It's only when it hits home, like when you receive a cease and desist letter from a trademark attorney for opening a restaurant called Burger Queen, or digital rights management software stops you from listening to your iTunes downloads on your Zune. Maybe your YouTube video gets taken down because of that T-Swizzy song in the background. That's what the kids call Taylor Swift. Maybe you get a letter from your internet service provider informing you that someone using your account has downloaded every episode of Game of Thrones, and that if it keeps up, you may be fined or imprisoned or beheaded. That's when it flares up. Flare up? God, are we still on the digestive tract metaphor? Somebody get me a Tums. Tums, by the way, a registered trademark of the GlaxoSmithKline group of companies. Most of us encounter IP only on its borders. We hear horror stories about the motion picture and recording industries suing grandmothers. We watch those unskippable FBI messages warning us about the consequences of copyright infringement, or we complain about paying thousands of dollars per pill for medicine. We tend to encounter intellectual property law in places where we, as users, are basically being told no. And being told no over and over again is irritating, especially when these no's don't seem to make any sense. And they're really irritating when they come with threats of fines or imprisonment. So in this course, we're going to focus less on enforcement and the no's, and more on the part of intellectual property that often says yes, sometimes, maybe, it is certain, or even ask again later. I'm speaking, of course, of the liquid-filled dye agitator containing a dye having raised indicia on the facets thereof, registered as patent US 3119621, which you might know as the Magic 8-Ball. Before we get too far, we should probably define intellectual property. This is going to get pretty abstract, so let's go to the thought bubble. The theoretical definition of intellectual property would begin by saying that it is non-physical property that stems from, is identified as, and whose value is based on an idea or some ideas. There has to be some element of novelty. The thing that we describe as intellectual property can't be commonplace or generally known in the society where it's created at the time that it becomes property. You can't claim that you invented the wheel or that you wrote Moby Dick. Even though the source material for all IP is social, the inputs are our education, our human interactions, and basically all the sensory data around us that we take in. The thing that we call IP is the product of us putting together all these social inputs into something that we're going to call the idea. Only the concrete, tangible, or physical embodiments of the idea are protected by intellectual property law. The idea has to be fixed into a form and location in which humans have access to it. That could be a novel, or a logo, or a liquid-filled dye agitator containing a dye having raised indicia on the facets thereof. Thanks, Thought Bubble. So, in its purest and best form, IP is the propertization of intellectual effort and talent. In its most corrupt and worst form, intellectual property can be and has been used by the propertied and powerful to protect concentrated markets and broken business models. At its very worst, it can be used as a censorship tool. Intellectual property differs somewhat from real property like cars or houses because it's limited in duration and scope. For example, copyrights last for the life of the author plus 70 years. Copyrighted works can be copied under the fair use exception for certain personal or publicly beneficial uses. Let's say a book reviewer quotes long passages of a novel, then pans the book. It's likely the author of the book wouldn't grant permission for this type of use. But we want to encourage informed public discourse, so there's a good chance it would be found to be a fair use. Patent law has carved out a limited experimental use exception that permits minimal use of a patent for amusement, to satisfy idle curiosity, or for strictly philosophical inquiry. Again, the patent owner probably wouldn't like this, but the law wants to encourage individual tinkering. Both these limitations exist to serve the primary objective of intellectual property. That's to promote the progress of science and useful arts by increasing our stock of knowledge. So in this series, we're going to focus on the three main branches of intellectual property: copyrights, patents, and trademarks. We won't have time to get into some of the lesser cousins of the family like trade secrets or the right of publicity, but all of these are included under the umbrella of intellectual property. So in the coming weeks, we're going to try to get at some of the nuts and bolts of what intellectual property is. Because like it or not, IP is only going to become more and more relevant as our lives become more and more digital. So regardless of what or how you feel about any aspect of IP, it's probably a good idea to have some basic knowledge of it. It doesn't matter if you're a consumer or a creator of protected content or both. Is understanding IP going to help you? You may rely on it. See you next week. Crash Course Intellectual Property is filmed in the Chad and Stacy Imigholt studio here in sunny Indianapolis, Indiana, and it's made with the help of all of these nice workers for hire. If you'd like to help us make Crash Course in a monetary way that doesn't imply any ownership in the final work, You can subscribe at Patreon, a voluntary subscription service where you can support CrashCourse and help make it free for everyone forever. You can get great perks, but the greatest perk of all is the satisfaction of spreading knowledge, right? So thanks for watching. We'll see you next week. Hi, I'm Stan Muller. This is CrashCourse Intellectual Property, and today we're going to be talking about copyright law. As you might have guessed, the law of copyright relates to the right to copy. The copyright as it relates to copies of copyrightable works. You copy? Right, so the right to copy or reproduce copyright-protected works is only one of the exclusive rights granted by the law of copyright. We're also going to discuss what types of things can actually be copyrighted, what we call the subject matter. But first, let's talk a little bit about the history of copyright law in the United States. Why the United States? Not because the US is exceptional and not because I'm a cultural imperialist trying to erode the identity and fabric of foreign nations. Mostly it's just because we're making this video in the United States and copyright law is territorial. So in 1709, England passed the Statute of Anne, which is widely considered to be the first copyright law. The Statute of Anne was the first law to grant ownership rights to individual authors rather than to publishers or printers. Throughout the 18th century, several of the American colonies adopted copyright and copyright-like laws based on the Statute of Anne. The drafters of the U.S. Constitution inserted what is commonly called the Intellectual Property Clause in Article 1, Section 8, Clause 8, and reads, "The Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings." So, listed right up there with Congress's power to lay and collect taxes and to declare war and to gather armies is the power to promote the progress of learning and knowledge through the grant of a limited monopoly to authors and inventors in the form of copyrights and patents. It is, without question, the coolest of the congressional powers. Stan, does that seem biased? Oh, I'm Stan. Mark? Does that seem biased? No? Good. The law has undergone several major revisions in the past 225 years, and it's currently in the process of a major review. So let's talk about what types of works are eligible for copyright protection and what rights authors or owners have in those works. Copyright law protects original works of authorship. Originality in the context of copyright means only that the work owes its origin to the author. That is, it's independently created and isn't copied from other works. How creative do these original works have to be, though? Not very, at all. For a work to be copyrightable, there only needs to be a minimal amount of creativity. Adult judges in court have described it as a scintilla, a dab, even a glimmer. So why is the bar for creativity set so low? Well, it's because lawmakers and judges probably aren't the best people to decide what types of creative works promote the progress of knowledge. Supreme Court Justice Oliver Wendell Holmes said, "It would be a dangerous undertaking for persons trained only to the law to constitute themselves judges of the worth of pictorial illustrations outside of the narrowest and most obvious limits." Holmes may have been speaking specifically about pictorial illustrations in this case, but the principle applies to any type of creative work. Anyway, Holmes clearly feels that judges don't necessarily make the best art critics. So what does Holmes mean by narrow and obvious limits? Well, words and short phrases like names, John Green, titles like The Fault in Our Stars, slogans, One Sick Love Story, fonts, coloring, mere listings of ingredients or contents, familiar symbols or designs like an 8-ball, none of this is protectable under copyright law. Are they protected by any other branch of intellectual property? Ask again later. One quick note, in order for a work to be protected by copyright, it need not in and of itself promote the progress of science. From literary novels to the most graphic pornography, it's probably protectable. The courts have concluded that it isn't a question of whether a work promotes the progress of knowledge, but that all works are granted equal protection. In this way, the law encourages people to create a diverse array of stuff. At the end of the day, it's the system that promotes the progress of science and not the individual works. Copyright law protects original works of authorship. Works of authorship fall into any of the 8 categories that are listed in the Copyright Act. Literary works are basically anything that can be embodied by letters or numbers, including novels, blogs, computer programs, websites, databases, and possibly really creative tweets. Musical works refers to the actual musical notation of a song by, say, T. Swizzy. Sound recordings are the actual music embodied in the record or the CD or an MP3, and it extends to things like audiobooks. That's what you actually hear. Dramatic works, which are basically stage productions like Wicked or Cats or Waiting for Godot, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures, and even architectural works. All of these are considered to be writings. Congress has indicated that this list isn't exhaustive, and it's vague on purpose because humans are coming up with new ways to express themselves all the time. Believe it or not, this is not the apex of human creativity. So imagining the Guggenheim or a mime routine as writing can feel like a stretch. In order for any of these works to be considered bona fide writings in the constitutional sense, they must be fixed in any tangible medium of expression, be that a book, an MP3, source code, choreography, a blueprint, or whatever. The only requirement for a tangible medium of expression is that we, as humans, either on our own or by using a computer or some other device, be able to perceive it in the form of a copy or record. This brings up a widely misunderstood aspect of copyright. Copyright protection extends to the intangible material, the literary work, not the physical copy of the work. You may own the copy of the book, but you don't own the copyright. Also, copyright extends only to expression and not to ideas. If you come up with $1 million idea for the best movie ever made or the greatest novel in history, until you actually write these masterpieces and fix them in a tangible medium, copyright law doesn't protect you. And you can't copyright facts. Let's say you do some research and discover that Matthew Buchinger was born in Germany on June 3rd, 1674, without hands or legs. He was a famous artist, calligrapher, and magician. He was called the Little Man of Nuremberg and the greatest German living. And he was married 4 times, fathered at least 14 children by 8 different women. Even if you spend your entire academic career uncovering these fascinating facts, facts alone aren't copyrightable. A biography of Buchinger would qualify for copyright protection, but only the narrative expression would qualify. Subsequent biographers could use the facts you uncovered in your research, but would be prohibited from expressing those facts using your words. They'd have to make up their own. Sans faire, or scenes that must be done, are not copyrightable either. These are well-worn storylines like a pair of star-crossed lovers from feuding families, or fables, or folklore. This sounds to me like a cliche. You can't copyright stuff like the idea of a dastardly villain tying a damsel to a train track. Finally, works created by the federal government can't be copyrighted. That's why we can show you this, and this, and this, no charge! Thanks, federal employees. So who can get a copyright? Well, according to the 1976 Copyright Act, ownership initially goes to the author or authors of the work. One of the only limits to this rule is that the individual author has to be a human being. If the work is created by an entity other than a human, like say, a monkey or a mindless automaton or an employee, that creator is not an author. I'm kidding, okay? Employees are humans. But that does bring us very nicely to the idea of works made for hire. Let's go to the thought bubble. So, if your boss tells you to create something, then your boss or the company you both work for is considered to be the author of that something. A work made for hire can be a work prepared by an employee within the scope of his or her employment, or certain works that are specially ordered or commissioned. Many employment contracts spell out what constitutes work made for hire. If they don't, or if there's no clear employee-employer relationship, courts look at things like whether the employee used the employer's computer, created the work during normal work hours, or was directed by a supervisor during the creation process. If it seems that there was an employer-employee relationship and the employee created the work while acting within the scope of that employee's duties, it probably was a work made for hire. So in these cases, the employer is considered to be the author. The actual people who created the work have no economic rights in the work, other than the fact that they were compensated for their efforts. This video is a work for hire. Frank's script, my performance, Mark's direction, Zuleia's script supervision, Brandon's editing, Thought Cafe's animations, Jason's music, these are all components of this motion picture work, and they all belong to the company we work for. One interesting question here is what rights, if any, you may have if you support CrashCourse via Patreon. Are you, as a paying supporter, functioning as our employer? Did you commission this work? Is this a work made for hire authored by tens of thousands of supporters? If you participate in a crowdfunding scheme where subscribers vote on or suggest the direction of the creative work, are you joint authors? Magic 8 Ball? Huh. Better not tell you now. Thanks, Thought Bubble. So, authors have a bundle of exclusive rights in their copyrighted works. They get these rights at the moment the work is created. Authors don't have to register their works to be protected, but there are benefits to registration. For example, authors can't go to federal court to enforce their copyrights unless they've registered it. The reproduction right is, put simply, the right to copy. Under US law, reproduction relates only to copying that produces copies or phonorecords, which, as we just learned, have to be fixed, tangible, and intelligible. In a lot of ways, our modern digital world is just an intricate network of copying. Think about how this video got from me to you. I don't even know where the actual copy of this work resides. We have a master copy on a hard drive in the closet over there, but the copy you're viewing has been uploaded and copied to Google servers, and then it gets transferred and copied from server to server across the internet until it reaches you, where an intricate sequence of copying takes place in your device's processor and memory so that you can stream it and view it. So in this system where damages pile up for every instance of infringement, and statutory damages can be as much as $150,000 every time an infringing copy is made, get out the confetti cannon because we are rich! What? Most of these temporary copies aren't fixed or tangible? Are you sure? We're not rich? Well, let's get an employee or a mindless automaton in here to clean up all this confetti. Hey! Hey, Roomba! Roomba is a registered trademark of the iRobot Corporation. Okay, so the adaptation right means that copyright owners have the exclusive right to create or authorize any translation, musical arrangement, dramatization, fictionalization, motion picture version, sound recording, art reproduction, abridgment, condensation, or any other form in which the work may be recast, transformed, or adapted. Under the distribution right, copyright owners have the right to distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. This seems pretty straightforward until the internet happened. In a digital world, what counts as a distribution? Things like streaming video services, torrent sharing, even the idea of licensing media from marketplaces like iTunes are fairly new, and the law has struggled to keep pace with the emerging technology. Really, all we can do is ask our trusty liquid-filled diagitator. Reply hazy. Ask again later. You know, I don't think this thing's magic at all. These answers are ambiguous and they seem to be arbitrary, and I don't think you should make your decisions based on this. But anyway, the public performance right allows copyright owners to recite, render, play, dance, or act any copyright-protected work, either directly or by means of any device or process. The Supreme Court recently ruled that Aereo, an online video service, made an illegal public performance when it let customers view broadcast television over the internet. Aereo argued that since each of their customers were assigned an individual antenna, when they would transmit the over-the-air broadcast to each user, it was a private performance. The court disagreed. Under the public display right, copyright owners have the exclusive right to display their works. In 1995, a sixth right, digital audio transmission, was created. This is what comes into play whenever you stream music on Spotify or Pandora. Under the most recent version of the US copyright law, these exclusive rights last for the lifetime of the author plus 70 years. For works made for hire, terms last for 95 years from publication or 120 years from the date of creation, whichever is shorter. So that means this video won't enter the public domain until January 1st, 2111. That is a long time. A lot of people think that's too long. Some people think that's not long enough. What do you think? Tell us in comments, and we'll see you next week. CrashCourse Intellectual Property is filmed at the Chad and Stacy Imigholtz studio in Indianapolis, Indiana, and it's made by all of these nice workers for hire. If you'd like to keep CrashCourse free for everyone forever, you can fund the series at Patreon, a crowdfunding platform that allows you to support the content you love. You can get awesome rewards for your support, but you do not get ownership of the CrashCourse copyright. Sorry. The greatest reward, though, is helping people learn stuff. Thanks for watching. We'll see you next week. Hi, I'm Stan Muller, this is CrashCourse Intellectual Property, and today we're continuing our discussion of copyright law. In his 2011 book, Infringement Nation, Professor John Turanian conducts a thought experiment where he tracks a guy's encounter with copyright law through the course of an unremarkable day. Well, we're going to try this experiment, and I don't really think it'll end up being a completely unremarkable day. I mean, in our version, I end up getting a tattoo, which for me would be memorable. Look, I don't like to front-load the animation sequences like this, but since we're doing a thought experiment, we're gonna have to do it in the thought bubble. As soon as I wake up, I check my Twitter feed. I spend the next 35 minutes or so retweeting everything One Direction posted while I was asleep, and each retweet creates what might be an unauthorized reproduction of 1D's copyrighted text. The same thing happens with my email, and suddenly I'm liable for millions in damages before I even get out of the bed. Once I'm at work, I spend the morning procrastinating and doodle pictures of Finn and Jake from Adventure Time, TPing Frank Gehry's J. Pritzker Pavilion, infringing on Time Warner's copyrights in the characters, and on Frank Gehry's architectural rendering. After 8 hours of work, my doodles are good enough to have them tattooed on my left shoulder. I commission this infringing work made for hire, and then I head off to my water aerobics class, sporting my fresh ink. When I hit the pool and Esther and Betty and Dorcas ooh and ah over my sweet new tat, I've engaged in a public display of this infringing work. Beyond another few $100,000 in statutory liability, the Copyright Act allows for the impounding and destruction or other reasonable disposition of any infringing work. That means Time Warner can either force me to have the tattoo removed, or they can opt to destroy me. Later, I post a bunch of my friends' pictures to my Facebook timeline, and by posting those, I'm making an unauthorized copy, distribution, and public display of her copyrighted photographs. I then head to another friend's birthday party, where I use my phone to record everyone singing the Happy Birthday song, which still earns an estimated $2 million per year, and is actively enforced, despite the fact that it likely isn't even protected by copyright law. At the same time, I accidentally capture and make a copy of the artwork on the wall of the restaurant. So at the end of this hypothetical day, I could be liable for millions of dollars, and I might be destroyed. By the end of the year, I'd be liable for more than $18 billion, and if I hadn't been destroyed, I would have a wicked bunch of scars from all that tattoo removal. Thanks, Thought Bubble. So, this story makes a few key assumptions. 1, full enforcement by copyright owners. 2, a court assessing the maximum statutory damages per instance of infringement. And 3, the absence of the mitigating effects of copyright exceptions and limitations. To me, the worrying thing about this scenario is that so much of our normal, everyday behavior puts us at risk of infringing copyright, especially when so much of our life is digital. To quote Professor Ian Hargraves, the copyright regime cannot be considered fit for the digital age when millions of citizens are in daily breach of copyright, simply for shifting a piece of music or video from one device to another. People are confused about what is allowed and what is not, with the risk that the law falls into disrepute. In other words, when the law is so broad that pretty much everyone is a copyright infringer, people stop paying attention to those laws. When the laws fail to keep up with technology, it loses legitimacy, and we become a nation of scofflaws. So to make copyright laws work in the digital age, there have to be copyright exceptions and limitations. And there are. Fair use is the most famous exception, and we'll get to that in a minute, but there are also some more specific exceptions and limitations we should look at. These exceptions cover a lot of different uses, like reproduction of copyrighted works for blind and disabled persons. They allow libraries and archives to preserve, copy, and distribute protected works. It also limits libraries' liability when a patron uses the copying machine to photocopy protected materials. The first sale rule under Section 109 means that once a copyright owner sells you a legal copy of a book or something, they no longer control the distribution rights of that particular copy of the work. You, as the owner of a lawfully made copy, may sell, rent, donate it, or whatever. This is why libraries can loan you a book and what allows you to sell your books and music to secondhand stores, if anyone does that anymore. It's also what allows the 3 remaining video rental stores in America to stay open. So this gives you the right to sell your books and CDs, but you probably can't sell the digital music and books that you buy from Apple or Amazon. The courts say that the first sale right applies only to the distribution right and not the reproduction right. Since selling your MP3 collection would require making a copy of those files, that is a no-no. As the law stands now, there is no legal secondary market for digital works of any type. When you click on that purchase or buy button, you're really not buying a copy of the work, you're entering into a type of licensing arrangement. And that's fine. I mean, that licensing agreement is in the terms of use, which I'm sure you read. No? Didn't read it? Well, I'm sure you clicked accept, or even I understand and accept when you created your Apple or Google or Amazon account, so you're in the agreement. Some types of works, like musical compositions and sound recordings, for example, are subject to compulsory or statutory licenses for certain uses. These licenses provide legal authorization to use a copyrighted work in certain ways or for certain purposes, as long as the user pays the required fee and otherwise meets the conditions in the law. The copyright owner can't deny you permission as long as you pay up. This is how artists get away with covering other artists' songs. They just pay the fee to the original rights holders, and they're free to release their version. You might have noticed that cover versions of popular songs are kind of a big deal on YouTube. Searching Frozen cover turns up about 2.8 million results. How does this work? Well, in 2011, YouTube entered into an agreement with several major music publishers to allow cover versions of songs to reside on the site, with part of the advertising revenue going to the original rights holders. So those are a few of the specialized exceptions and limitations to copyright enforcement. But by far the broadest, most flexible, most controversial, and most famous copyright exception is fair use. Courts have said the fair use defense allows them to, quote, avoid rigid application of the copyright statute when, on occasion, it would stifle the very creativity which that law is designed to foster. Fair use acts like a safety valve. It allows for certain socially beneficial uses that you may otherwise get in trouble for. To paraphrase an 1841 court decision, the progress of learning advances when the law allows follow-on authors to bestow their intellectual labor and judgment in reworking selections from a prior work without prejudicing the profits or prospects of that work. What? Who would say this? You know, Mark, I would love to advance the progress of learning by bestowing my intellectual labor and judgment on the reworking of this prior work, but I just worry about prejudicing the profits or the prospects of that work. Anyway, fair use is an affirmative defense, which means the defendant must show and prove that the use was fair and not an infringement. The only way to definitively find out whether something is a fair use is by having a judge tell you it is. And this is a problem when taking a copyright case through trial costs anywhere from $300,000 to a couple $1 million. Some courts have called the fair use exception the most troublesome in the whole law of copyright, and they are not wrong. I mean, the term fair use isn't defined in the Copyright Act, and courts have a lot of leeway in how they decide if something is a fair use. Courts have to consider all the factual evidence at hand for each particular case, and every case is different thanks to the huge variety of copyrightable works and the many contexts in which these works works can be used, like classroom lessons, blog posts, YouTube videos, or in a project where the entire contents of a university library are digitized. So, how to decide? Courts use 4 factors to determine whether a use is fair. The first factor is the purpose and character of the use, like whether the use is commercial or is for nonprofit educational purposes. Non-commercial or educational uses weigh in favor of fair use. In the last 20 years, courts have expanded this factor to include consideration of whether the work is transformative. They look at whether the use actually transforms the underlying purpose of the work by adding a new meaning or message. Courts often hold that parody is a transformative fair use. Parody functions as a critical commentary of the original work. Courts have also recently held that a project to digitize large collections of works and the making available of small segments of text from those works are transformative uses. That makes the Google Books project a fair use. That Google Books decision is currently in the appeals process though, so it might not hold up. Publishers and authors will argue that merely copying all these books without adding expression or value other than placing the work within a highly commercialized digital ecosystem in a crass attempt to attract users is not transformative. Google tells a slightly different story. They'd say the project makes these works searchable, discoverable, and universally accessible, and that is a transformative use with significant public benefit. The second factor has to do with the nature of the copyrighted work. Courts have consistently held that the more original and creative a work is, the more protection it's given from copying, and it's less likely that a court will find fair use. On the other hand, the more informational or functional the plaintiff's work, the broader the scope of the fair use defense. In practice, this means that fictional works tend to have a stronger copyright protection as they're works of imagination. They're basically pure expression. Non-fiction works like news, biographies, and encyclopedias are filled with uncopyrightable facts. This means they require less creativity to make, and they're granted less protection under copyright law. The third factor basically looks at how much of the work you use, and there are 2 parts to this factor. The first is quantitative substantiality. That looks at the amount of the work you use, like how much of the video or how many pages of the book. So wait a minute, how did we get this far into an episode about exceptions without rolling the Mongoltage? Hit it! The Mongoltage, besides being awesome, is an excellent example of this factor. We used 3 clips for a total of 3 seconds out of a 90-minute film. I think we have a pretty good case that this use isn't quantitatively substantial. The other part of this is qualitative substantiality. This refers to a use that borrows only the most valuable part of the source work. While I would argue that the clips that comprise the Mongoltage are the most important and valuable parts of 1963's Hercules versus the Mongols, a court would probably find that these clips aren't the heart of the film. Spoiler alert, the heart of the film is when Hercules kills Genghis Khan. The fourth factor addresses the effect of the use on the potential market for or value of the copyrighted work. What we're looking at here is whether the derivative work has harmed the copyright owner's ability to make money from the original. Courts try to weigh any public benefit derived from the new use with the personal gain the original owner will receive if the use is prohibited. If your use doesn't damage the original copyright owner's ability to make money, you don't have to show a whole lot of public benefit. It's just hard to argue that you uploading Interstellar to your YouTube channel has any public benefit. While these 4 factors are most often used to determine fair use, courts can weigh any other factors that they deem relevant, including broad considerations of whether the use will advance the public interest and the goals of the Copyright Act. Unfortunately, this means that there is no clear formula for how courts determine fair use. Fair use is designed to be a flexible tool, and any rule that's flexible is necessarily unpredictable. Yet, many people have argued that fair use has become predictable in recent years. A string of court decisions have expanded the meaning of what is considered to be a transformative fair use. Courts are carving out policy-specific areas like education, where uses are pretty likely to be allowed. User groups have published best practices documents, many of which are available online. We've got some links down below. Authors and publishers argue that courts have expanded the breadth of fair use too far and that these best practices guides are biased in favor of expanding fair use. In the Supreme Court case Harper and Row versus the Nation, the majority opinion coined what I like to call the copyright golden rule. Take not from others to such an extent and in such a manner that you would be resentful if they so took from you. Thanks for watching. I'll see you next week. Crash Course Intellectual Property is filmed at the Chad and Stacy Imigholt Studio in Indianapolis, Indiana, and it's made by all of these nice workers for hire. If you'd like to keep Crash Course freely available for everyone forever, you can support the series at Patreon, a crowdfunding platform that allows you to support the content you love. Speaking of Patreon, we'd like to thank our Headmaster of Learning, Thomas Frank, and our Vice Principals, Kathy and Tim Phillip, and Linnea Boyev. Thank you so much for supporting Crash Course. You can get awesome rewards for your support, but you don't get ownership of our Crash Course copyright. You do, however, get to help people learn. Thanks for watching. We'll see you next week. Hi, I'm Stan Muller. This is Crash Course Intellectual Property, and today we're talking about patent law. That's why I'm wearing these fancy patent leather shoes. They're a little too small, and I had a hard time putting them on. If only somebody would invent a new, useful, and non-obvious tool for forcing feet into too small shoes. Mark, can I take these off now? A patent is a grant by a government that allows an inventor to maintain a monopoly on the use and development of an invention for a limited time. Patents allow inventors to prevent or exclude other people or companies from manufacturing, selling, or using their patented inventions. Governments grant these exclusive rights in exchange for the clear and detailed public disclosure of inventions. So here's the deal. You invent something awesome, explain how you did it in patently obvious terms, we'll let you be the sole owner for a couple of decades or so, which should give you enough time to make some money off the thing. Ideally, you'll get rich for your inventive efforts before the term expires, or maybe you'll pour all that money into more research and develop new patents. The notion of giving talented inventors and innovators a limited monopoly in exchange for their instructing the rest of their less talented fellow citizens is not new. It's generally accepted that the first systematic patent law was developed in Venice, a hotbed of Renaissance industrial activity. The 1474 Venetian patent statute sums up the economic rationale of patent law pretty nicely. We have among us men of great genius, apt to invent and discover ingenious devices. And in view of the grandeur and virtue of our city, more such men come to us every day from diverse parts. Now, if provision were made for the works and devices discovered by such persons, so that others who may see them could not build them and take the inventor's honor away, more men would then apply their genius, would discover, and would build devices of great utility and benefit to our commonwealth. Wow, these Venetians really thought a lot of themselves. Grandeur and virtue of our city. This idea of granting exclusive rights to inventors to encourage discovery spread throughout Europe, into England, and then to the United States, where it was incorporated into the US Constitution. In order for an innovation or invention to be patentable, the invention must satisfy 5 requirements. We'll look at all of these requirements generally, and we'll look at the patent for a trusty liquid-filled diagitator containing a dye having raised indicia on the facets thereof. Magic 8 Ball's patent was issued in 1964, and did it meet all these requirements? Yes. So this seems a little circular, but the first requirement is that the patent subject matter be patentable. The categories for patentable subject matter are defined broadly as any process, machine, manufacture, or composition of matter or improvement thereof. The Supreme Court has interpreted this to mean that anything under the sun that is made by human beings is patentable. However broad this definition might be, certain things like the laws of nature, physical phenomenon, abstract ideas have consistently been held not to be patentable. The distinction here is that the innovation has to be the product of human inventiveness and not the product of nature. The Supreme Court recently looked at this issue in a 2013 case involving a biotech firm that had isolated human DNA linked to ovarian and breast cancer. The company argued that it had developed an innovative process for looking for mutations that might lead to cancer and isolating them. They argued that the isolated genes were the product of human inventiveness and therefore patentable. The court disagreed, finding that a naturally occurring DNA segment is a product of nature and not patent eligible merely because it's been isolated. The Magic 8 Ball is certainly the product of human inventiveness, although it would be fantastic if these were formed by nature, like if they washed up on beaches or maybe there was a Magic 8 Ball tree. I use fantastic here in the sense that this is obviously a fantasy. But, what a world that would be. So are you patentable subject matter or what? It is certain. The second requirement for patentability is that the invention be useful, which means both that it has some identifiable benefit and that it's capable of being used. Patent law often refers to a person of ordinary skill in the art. What they're talking about here is an engineer or fellow inventor that can understand the technical information included in the patent. This differs from like tort law, where the law often refers to a reasonable person standard. Understanding patents requires a little more technical expertise. I mention this because the second requirement relies on a person skilled in the art to accept that the invention described in the patent is useful and that it works. The Magic 8 Ball is very useful. It functions in the way that the patent claims it does. It displays answers to yes or no questions such as, should I join the Merchant Marines or will I die alone? Are you useful? It is decidedly so. The third requirement for patent protection is that the invention be new or novel. Basically, if somebody else already invented or patented a similar invention, you can't get a patent. Going back to the case of our Magic 8 Ball, despite the fact that its application notes that similar devices exist, the novelty of the 1964 version lies in the shape of the die, which allows for a better question and answer experience. Are you novel? That looked good. The innovation must also be non-obvious. The test for non-obviousness is whether the innovation and the prior art, by which I mean all that which has come before the innovation, are such that the innovation as a whole would not have been obvious to a person having ordinary skill in the art at the time the invention was made. This is kind of a difficult theoretical task for a judge or patent examiner. Sometimes the most inventive leaps of logic yield solutions that are so elegant that they seem obvious once you've seen it. The Magic 8 Ball 1964 patent was for an improvement to the original invention. The inventor added many more sides to the die and also added the all-important raised indicia, the raised lettering, so as to prevent bubbling between the glass viewing screen and the die. Doesn't seem obvious to me. Magic 8 Ball, are you non-obvious? Without a doubt. The final requirement is enablement. Technically, this means the specification of the patent shall contain a written description of the invention and of the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains to make and use the same, and shall set forth the best mode contemplated by the inventor of carrying out his invention. Whoever wrote this doesn't understand the terms clear and concise. What they're saying is that the plans submitted with the patent have to be clear and complete enough for someone else to recreate the invention without too much trouble. Beyond this, the applicant has to disclose the best mode of making this thing happen. The inventor can't give people the runaround. If there's a best way to recreate the invention in question, the inventor is required to disclose it. This final step is essential to the underlying rationale of patent law. Without a clear and accurate explanation of how to make and use the innovation, the public gets nothing in return for granting the limited monopoly. So, what's it going to be, Magic 8 Ball? Can we make or use you based on the patent's description? As I see it, yes. There are three types of patents issued by the Patent and Trademark Office: utility patents, design patents, and plant patents. The 5 requirements we just talked about refer to utility patents. Design patents cover any new, original, and ornamental rather than useful article of manufacture. Apple is famous for their design patents and their utility patents. Plant patents are granted to persons who first notice the distinctiveness of a plant, then reproduce it asexually by grafting or cloning rather than growing from a seed. If you grow it from a seed, you can't patent it. The plant must be novel and distinctive to be granted a patent, which basically means that it has to have at least one significant distinguishing characteristic to establish it as a distinct variety. So this is what a plant patent looks like. Not a lot of them get issued relative to utility or design patents. On a related note, a human-made plant, or a plant that's been genetically engineered, can also be the subject of a utility patent, provided it meets all the 5 requirements we talked about. Often, these are plants that are resistant to certain herbicides or better suited to shipping. There's even a man-made variety of cotton that's resistant to pests. Patents don't last forever. The term of protection for utility patents is 20 years measured from the date of filing. There are extensions of up to 5 years allowed for drugs, medical devices, and additives. The current term of protection for design patents is 14 years, and that's also from the date of filing. So patents are all about the money. Let's talk about that in the thought bubble. In terms of economic impact, patent law is arguably the most important branch of intellectual property. There are legitimate questions about the role of patents and what types of research and development patent law encourages. Does the law encourage more research into highly lucrative erectile dysfunction medication than stuff like anti-malarial drugs? Should developing nations be able to create public health exceptions for life-saving proprietary medications? If so, then how would companies be able to pay for the development of these medications or future life-saving medications without the assurance of patent protection? And then there are non-practicing entities, often called patent trolls, that go around acquiring huge patent portfolios and then threaten to sue pretty much everybody. Patent trolls bring these lawsuits despite the fact that they have no interest in developing or manufacturing any actual products. This is their business model. Because of the high cost of litigation, costs can range from about $1 million to $5 million if this goes to trial, and the threat of massive damage awards, most companies sued by patent trolls settle or agree to pay licensing fees to the trolls. There's legislation pending in Congress designed to address this issue. Thanks, Thought Bubble. So, the policy issues around patents are incredibly complex and controversial, and this video is only a basic overview. The underlying purpose of patent law, which is to reward inventors for their skill and effort, is often in direct opposition to the public's interest in accessing those innovations. Whether it be life-saving medications that cost thousands of dollars per pill, or water treatment technologies that developing countries can't afford to license, the trick is to strike a balance between providing inventors with incentives and ensuring public access. How we attain that balance is still very much an open question. Thanks for watching. We'll see you next week. Crash Course Intellectual Property is filmed at the Chad and Stacy Imigholt studio in Indianapolis, Indiana, and it's made by all of these nice workers for hire. If you'd like to keep Crash Course freely available for everyone forever, you can support the series at Patreon, a crowdfunding platform that allows you to support the content you love. Speaking of Patreon, we'd like to thank our Headmaster of Learning, Thomas Frank, and our Vice Principals, Kathy and Tim Phillip, and Linnea Boyev. Thank you so much for supporting Crash Course. You can get awesome rewards for your support, but you don't get ownership of our Crash Course copyright. You do, however, get to help people learn. Thanks for watching. We'll see you next week. Hi, I'm Stan Muller. This is Crash Course Intellectual Property, and today we're talking about trademarks. Trademarks are everywhere, and they can often be confusing. So today we're going to talk about why just about everything seems to be trademarked, and why trademarks are good for business. Mr. Mueller, trademarks don't intersect with my life, so I really don't see why we need to cover this. 1, it's Mueller, and 2, just watch the video. A trademark is any word, name, symbol, or device used to identify and distinguish goods from those manufactured or sold by others, and to indicate the source of the goods, even if that source is unknown. This bit about unknown sources means that you, as a consumer, don't usually know the person or factory that actually made the goods you buy. Before the Industrial Revolution, you often knew exactly who was making your stuff and how it was made. If you wanted a hammer, you went to the blacksmith, and you knew his name. It was probably Smith. These days, brand names assure you that you're buying the same products, say toilet paper that you bought last time you went shopping, you know, like the stuff with the ripples. Seriously though, getting the wrong medication because of brand name confusion or counterfeiting could be disastrous. The rationale for granting legal protection for trademarks is that they're a type of property. It demonstrates to the purchasing public a standard of quality and embodies the goodwill and advertising investment of its owner. In other words, companies expend a tremendous amount of resources to develop the product, market it to customers, and provide customer support and back up their product with warranties. At its core, trademark law functions as a consumer protection measure. It prevents consumer confusion and makes it easier for consumers to select and purchase the goods and services they want. For example, if you go shopping for a new television, you don't have to sift through dozens of products that are confusingly similar to Samsung, knockoffs like Samsung or Wamsung or Sony. You want the Samsung, maybe based on past experience or the company's reputation or even a funny ad. Because the law protects the manufacturer's use of the trademark, you can be reasonably sure that the TV you're picking up at Best Buy is the TV you saw the Verge reporters freaking out about at CES. Though trademarks are often classified as intellectual property, the Supreme Court held in the 1879 trademark cases that Congress has no power to protect or regulate trademarks under the Intellectual Property Clause of the Constitution, which, as you'll recall, provides Congress with the authority to regulate and protect copyright and patents. But this didn't stop Congress from regulating trademarks. They used the Commerce Clause of the Constitution, which gives them the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Beyond trademarks, there are also service marks, which are very similar in that they distinguish one particular service. An example of a service mark is that roaring lion at the beginning of MGM movies. It's registered for motion picture production or something. Trade dress or product packaging is protected if it's distinctive and non-functional. Like the shape of a Nutter Butter cookie is protected trade dress. What they ought to trademark is the smell. Some people have registered smells, and we'll get to that in a minute. Trademarks are symbols, and since human beings might use as a symbol or device almost anything that is capable of carrying meaning, just about any conceivable thing can function as a trademark. Trademarks can be words like craft or Lego, logos, designs like the Nike swoosh, aromas like there's a brand of oil for race cars that smells like cherries, sounds like bong 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 or ba-da-da-da-dong or dong 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 or ba-da-ba-ba-ba. Even dough is a registered trademark. You can register colors like UPS brown or Home Depot orange or Tiffany blue or John Deere green. Personal names like Taylor Swift. T. Swizzy's name is registered for 61 different goods and services, from shoes to Christmas tree ornaments. Even containers like the Coca-Cola bottle or this perfume bottle shaped like a human skull can be registered. In short, they can be almost anything that distinguishes the product from others and which signifies the source of the goods. Despite the breadth of potential trademark subject matter, there are some limits on what can be a valid trademark. Recently, a restaurant in Texas asserted trademark rights in the flavor of its pizza. One of the restaurant's former employees allegedly stole the recipe and opened up a competing pizza joint, selling pizzas that tasted a lot like those made by his former employer. The judge rejected the claim and dismissed the case, finding that it is unlikely that flavors can ever be inherently distinctive because they do not automatically suggest a product's source. Also, functional product features are not protectable under trademark law. Pizza has only one function, that's to taste delicious. So there are 3 requirements for trademarks. We just discussed the first one, that a trademark has to be a symbol or device that a court or the Patent and Trademark Office deems to qualify. The second requirement is that the mark has to be used in interstate commerce, and the third is that it has to identify the mark owner's goods and distinguish them from those manufactured or sold by others. It has to be distinctive. Let's talk about trademarks and what makes them distinctive in the thought window. Courts rank trademark distinctiveness along a spectrum, ranging from unprotectable to highly protectable. At the bottom end of the spectrum is generic. Generic names refer to stuff like using the word orange for the fruit, or dog for the canine, or cheese for cheese. Descriptive terms simply describe the goods and convey an immediate idea of what the product is, such as break and bake for scored cookie dough. Suggestive marks require some imagination or perception to link them to the goods, like chic for Middle Eastern food or Fruit Loops for a circular fruit-flavored breakfast cereal. Arbitrary marks are common words used in unexpected ways. Apple for computers, or Amazon for book sales, or Shell for gasoline. The most distinctive marks are usually made-up words. Fanciful marks are non-dictionary words such as Google for an internet search engine, or Clorox for bleach, or Kodak for film. Fanciful, arbitrary, and suggestive marks receive automatic protection upon use because they're considered to be inherently distinctive. So the owner of the break and bake mark has to show that consumers identify the product with Nabisco or Pillsbury or whoever makes the product. I honestly don't know who makes it, which isn't a good sign as to whether it's acquired secondary meaning. Generic terms are never entitled to protection. This becomes important when trademarks are gradually assimilated into the language as common names. Through a process sometimes called genericide, the public comes to view such names as referring to the products themselves rather than as distinguishing the source of the products. As a result, the name loses its protection. Words like escalator, cellophane, and aspirin were all once protected by trademark. This process is ongoing today, and there are a lot of modern marks that are threatened by genericide, like Google, or Kleenex, or Photoshop, or Xerox. Thanks, Thought Bubble. So once an owner meets the requirements for trademark and has a protected product, they'll often put a TM or a little R in a circle next to a product name or brand. The TM shows that the owner is asserting trademark in the product. When you see the little circle R, that means the trademark has been registered with the US Patent and Trademark Office. Like in copyright law, once you're registered with the feds, you have standing to take your case to federal court and maybe be awarded damages. Once the PTO is satisfied that the mark meets all the requirements, the application is published for opposition. Anyone who might be affected by the registration has 30 days to oppose it. If no one opposes, the mark is registered. The owner is then required to file affidavits of continuous use. Basically, you have to submit proof that you're still selling the product associated with the trademark. You have to do this every 5 years to maintain the registration. Trademark owners can do this forever. This is different than patents and copyrights whose trademarks are doomed by the limited times language in the intellectual property clause. So when it comes to trademarks, you have to use it or lose it. Trademarks are often disputed, and in pretty much every case, likelihood of confusion is the central issue. The principle set forth in an 1877 Supreme Court opinion in an unfair competition case. What degree of resemblance is necessary to constitute an infringement is incapable of exact definition as applicable to all cases. All that courts of justice can do in that regard is to say that no trader can adopt a trademark so resembling that of another trader as that ordinary purchasers buying with ordinary caution are likely to be misled. Every court uses a slightly different set of criteria for deciding trademark cases. We're going to talk about the Seventh Circuit Court of the United States definition, which has 7 parts. Those criteria are 1. Similarity between the marks in appearance and suggestion. 2. Similarity of the products. 3. The area and manner of concurrent use, which means where in the United States the product is for sale. 4. The degree of care likely to be exercised by consumers. 5. The strength of the plaintiff's mark or how distinctive it is. 6. Whether there's evidence that people were actually confused, which is a pretty strong sign that there's a likelihood of confusion. And 7. Whether the defendant intended to palm off his product as that of the plaintiff. These factors are going to be weighed differently in individual cases, but the court has often noted that the similarity of the marks, the defendant's intent, and evidence of actual confusion are of particular importance. In addition, the Seventh Circuit has held that a court may consider other relevant factors, such as the party's marketing channels and whether a trademark is being used in a parody. Trademark protection is also available under certain circumstances, even in the absence of likely or actual confusion. The Federal Trademark Dilution Act benefits only famous trademarks against a weakening of their valuable distinctive quality. There are 2 basic types of dilution: dilution by blurring and dilution by tarnishment. Dilution by blurring happens when a similar trademark chips away at the distinctiveness of a famous trademark. For example, someone selling Apple brand toilet seats or bulldozers will blur the ability of Apple to identify a single source, even if people buying that stuff didn't think Apple Computer made their bulldozer. Dilution by tarnishment happens when similarity between a mark or trade name and a famous mark harms the reputation of the famous mark. For example, and this is a real case, a guy that uses the trade name Victor's Little Secret for a store selling sex-related products is likely to tarnish the famous Victoria's Secret mark. There's no real risk of confusion here, but the company Victoria's Secret is seeking to prevent the gradual tarnishing of their mark. One major issue with dilution is that famous trademarks are hard to come by. While there are supermarks like IBM, Google, Budweiser, and Microsoft, courts have typically been hesitant to find less well-known trademarks to be famous. It's not like YouTube or something where you can be kind of famous. Your trademark has to be really, actually IRL famous to attain this status. Trademarks are fascinating, regardless of whether you're someone who enjoys strolling through the shopping mall with logos firmly affixed to your bags and coffee and clothes, or whether you believe that brands and trademarks have become so powerful that they've been internalized by modern society and dictate our aspirations, our self-image, and our lifestyles. As we watch Don Draper and James Bond conspicuously guzzle Heinekens, maybe we worry that brands are controlling and corrupting our creative content. Regardless, trademarks are ubiquitous. Trademarks help us make sound decisions about the products we need and want. They protect us from knockoff goods, and they allow us to go about the daily business of our lives more quickly and more efficiently so that we can sit down, tune our Samsung television to PBS on our Comcast cable tuner, watch the season finale of Downton Abbey brought to you by Viking River Cruise Lines and Ralph Lauren. Thanks for watching, and as they say in Hank and John's hometown, don't forget to be awesome. Which is not a registered trademark, which is how this happened.
Tell either Eleanor or Alice not to forget to be awesome.
Oh.
Thank you, Sarah.
CrashCourse Intellectual Property is filmed at the Chad and Stacy Imigholt studio in Indianapolis, Indiana, and it's made by all of these nice workers for hire. If you'd like to keep CrashCourse freely available for everyone forever, you can support the series at Patreon, a crowdfunding platform that allows you to support the content you love. Speaking of Patreon, we'd like to thank our Headmaster of Learning, Thomas Frank, and our Vice Principals, Kathy and Tim Phillip, and Linnea Boyev. Thank you so much for supporting CrashCourse. You can get awesome rewards for your support. You cannot get ownership of the CrashCourse copyright, but you can get the satisfaction of helping people learn. Thanks for watching. We'll see you next week. Hi, I'm Stan Muller, and this is CrashCourse Intellectual Property. Today, we're talking about international intellectual property law. And the first thing I'm going to tell you is that there aren't really any international intellectual property rights. IP rights are territorial. They're created by each country's national law and typically apply only to conduct that takes place within that nation. So, there you have it. Thanks for watching. I'll see you next week. CrashCourse Intellectual Property is filmed in the Chad and Stacy Imig. Is this really all we have today? What about the complex web of international IP treaties that establish minimum standards for IP laws in countries around the world? Can we talk about that for 11 minutes? So all these international treaties set up ground rules for stuff like how long a copyright or patent should last, or the basic subject matter of trademarks. Countries that join these treaties can have higher protection standards, but the treaties set up a baseline of protection they must provide. The most important minimum standard set up by these treaties is the principle of national treatment, which operates something like an international IP golden rule. Do unto other countries' authors and inventors as you would have done unto your own. Basically, each country has to give foreigners IP protection that is no less favorable than the protection granted to its own people. These international treaties are a response to globalization. Political reforms have torn down the Iron Curtain, and trade with half the world that was basically off limits to the West a few years ago is now possible. China. Legal reforms have facilitated and expanded economic exchanges, and IP rights play a significant role in all channels of international trade. Sellers of goods are more likely to sell to a country that has strong IP rights, especially for products like computer software or films, where the product is basically pure IP. Beyond this, technological advances mean that someone might be watching this right now in Antarctica, and to that person I say, do you really have the bandwidth in Antarctica to watch CrashCourse? In any case, borders and distance mean less and less in a digitized world. But, as we discussed in CrashCourse World History, globalization is complicated. Some argue that ratcheting up IP minimum standards, especially in a world where around 90% of all technology royalties and licensing fees are received by 5 developed countries, is not always a good thing. Developed and developing nations often have very different attitudes toward intellectual property. Developed nations usually try to get full economic benefits from their inventions and knowledge through strong IP rights. They argue that strong IP laws are necessary to protect the significant investments of developing these products. Pharmaceuticals and feature films cost a lot to make, and the creators want a return on their investment. Rich countries also argue that strong intellectual property laws will make developing countries more attractive trade partners, because creators know their IP exports will be protected, so they're more likely to send stuff there. Developing nations argue that they need access to advanced technology and knowledge, which are the tools they need to develop, modernize, and compete in the modern world. They often view strong IP rights as a tool used to either deny access altogether to technology and knowledge, or to severely limit access via high royalties and licensing fees. So it's an open question as to who's right about this. Do you happen to know? Don't count on it. Yeah, me either. So we've got no answers, but let's take a look at the international frameworks for copyright, patents, and trademarks. The oldest and most important copyright treaty is the Berne Convention for the protection of literary and artistic works. The Berne Convention, as it's known, was first signed in 1886 in Bern, Switzerland, and was aimed at solving the problem of widely varying treatment of foreign authors among countries. The United States, for example, didn't grant copyrights to foreign works until 1891. In his 1842 reading tour of the United States, Charles Dickens was treated like a rock star, mostly because so many people were reading cheap, pirated editions of his books. And so the US press attacked him. To quote one outlet, "We are mortified and grieved that he should have been guilty of such great indelicacy and impropriety, asking us to do honor to his genius, but to look after his purse also." So we steal this guy's copyrights and then insult him for complaining about it. Welcome to America, Dickens. This state of affairs continued until 1878, when France convened an international literary congress with Victor Hugo, author of Les Miserables and The Hunchback of Notre Dame, as its head. As with all things created by Victor Hugo, it was way too long. The agreement was finally signed in 1886 by 10 countries. Today, there are 168 members of this treaty, which is administered by the World Intellectual Property Organization, or WIPO. The United States didn't officially join the Berne Convention until 1989, which also happens to be the year that the cinema classic and highly lucrative intellectual property Weekend at Bernie's was released. Is that a coincidence? Maybe. The Berne Convention adopts the aforementioned principle of national treatment and sets up certain minimum standards for the copyright laws of any country that signs on. Things like minimum copyright terms and the scope of exceptions and limitations to exclusive rights. The treaty also largely eliminates what are called formalities. Berne countries can't require that authors go through formalities like copyright registration or require a copyright notice or symbol to get protection. But without requirements that owners register their works and record ownership transfers with their particular government, ownership information is often lost and authors can't be located. This creates a lot of problems. Another problem with the Berne Convention is that it doesn't have an effective enforcement system. When a country violates the treaty, there's no effective way to punish them for it. Members do have the option of trying to settle the dispute through the International Court of Justice, but this option has been used exactly 0 times. A lot of these issues were resolved by the trade-related aspects of intellectual property rights, or TRIPS agreement. Formed in 1994, this agreement incorporates most of the Berne Convention and adds a few copyright bits of its own. The TRIPS agreement is administered by the World Trade Organization, and it has a strong enforcement mechanism in place under the WTO's dispute settlement body. So if a country doesn't comply, the WTO's like, WTF. They then decide whether there's a violation and what kind of punishment they need to impart. Beyond the Berne Convention and TRIPS, the World Intellectual Property Organization produced 2 multilateral treaties, the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. These are referred to as the Internet Treaties, and the US implemented them in 1998 through its introduction of the Digital Millennium Copyright Act, or the DMCA, which you, as an internet user, probably hate. International copyright is enormously complex. Luckily, international patent law is dead simple. Nah, it's enormously complex too. Let's go to the thought bubble. As the Industrial Revolution advanced across Europe and North America, differences in countries' patent laws piqued an interest in creating international standards for patents. The International Convention for the Protection of Intellectual Property, commonly known as the Paris Convention, was signed in 1883 in Paris, France. Like the Berne Convention, the Paris Convention lacks an adequate enforcement mechanism. If a country violates the treaty, everybody's back in the International Court of Justice. But, just as with copyrights, nobody does this. Because the Paris Convention didn't really set minimum standards, countries had great freedom to tailor their patent laws to their own needs and interests. Developing countries, for example, might exclude pharmaceutical products from patentability because they feel like health-related products and medicine should be affordable for people to buy. Many developed nations successfully sought to close this gap during negotiations of our old frenemy, the TRIPS agreement. TRIPS incorporates parts of the Paris Convention and sets forth a number of minimum standards for patent protection. TRIPS prevents World Trade Organization members from denying patents to pharmaceuticals or biotechnology products or processes. Unlike the Berne Convention, which does away with copyright formalities, the Paris Convention assumes that the inventor has to apply to his or her particular government's patent office or government. Countries that are party to the convention can't give foreign inventors a hard time. They get the same protections that apply to domestic inventors. The Patent Cooperation Treaty makes this easier. It helps coordinate procedures for filing multiple patent applications for the same invention in several countries around the world. Thanks, Thought Bubble. So the Paris Convention also governs trademarks. In many ways, it treats trademarks like patents. It requires countries to provide for national treatment. Because trademark law is territorial and you have to apply for protection in each country where use is planned, there are 2 special agreements that establish a common international registration system. These are the 1891 Madrid Agreement concerning the international registration of marks and the 1989 Madrid Protocol for relating to the Madrid Agreement. Aside from all these European capitals and their agreements and conventions and protocols, the TRIPS agreement extends protection to geographical indications. This means that the word champagne can only be used used for sparkling wine produced in France's Champagne region. It also extends to words like Bordeaux, Chablis, Parma ham, Roquefort cheese, Florida orange juice, Vermont white cheddar, all that business. These issues have been a point of contention between the US and the EU. Europe has long pushed for greater protection of geographical indications. Every time you eat Greek yogurt or feta cheese, every time you smoke a Cuban cigar, every time you stir up a cup of Swiss Miss hot chocolate, every time you're confounded by a Chinese finger trap, you're seeing a potential geographical indication violation. At the end of the day, international intellectual property is all about setting minimum standards and national treatment. It's about countries treating the nationals of other countries at least as well as they treat their own. This push for standardization has caused some problems. There are now so many IP treaties and agreements and protocols in place that it makes intellectual property reform difficult. So for example, changing the law to reduce the copyright term in the United States isn't just a matter of changing the US law. It's a matter of changing all of these international agreements. Just as individual nations struggle to keep pace with our increasingly globalized world, so does the international intellectual property system. Both national and international systems are struggling to find the right balance of exclusive rights and public access to knowledge in a world where borders are traversed with a click. Thanks for watching. We'll see you next week. CrashCourse Intellectual Property is filmed in the Chad and Stacy Imigholtz studio in beautiful Indianapolis, Indiana, and it's made by this crew of international creators. If you'd like to keep CrashCourse free for everyone forever, you can support the series at Patreon, a crowdfunding platform that allows you to support the content you love. Speaking of Patreon, we'd like to thank all of our patrons in general, and we'd like to specifically thank our Headmaster of Learning, Thomas Frank, and our Vice Principals, Kathy and Tim Phillip, and Linnea Boyev. We've got awesome rewards at our Patreon page, but the greatest reward of all is helping people learn stuff, right? Thanks for watching. We'll see you next week. Hi, I'm Stan Muller, and this is the final episode of CrashCourse Intellectual Property. Tackling such a huge subject in only 7 episodes has meant that we can't go into quite as much detail as we'd like, but hopefully we've given you a pretty good overview of the basics of intellectual property. We spent the last 6 episodes talking about copyright, patent, and trademark laws as they currently exist, but we keep running into a roadblock. Intellectual property law is slow to change, and we're living in a world that's changing pretty rapidly. As we've noted again and again, our new digital world has raised challenges for both consumers and producers of IP. So today we're going to look at some of the problems that have developed in recent years with intellectual property. We're also going to talk about IP as it applies to everyone's favorite internet media hub, YouTube, and we're even going to look into the future. I mean, we've got this liquid-filled dye agitator containing a dye with raised indicia on the facets thereof. This thing tells the future, right? It is certain. So YouTube's kind of a big deal. It has over 1 billion users watching hundreds of millions of hours of video and generates billions and billions of views. At the time we made this, over 300 hours of video are uploaded to YouTube servers every minute. And in its 10-year history, YouTube has become the audiovisual wing in Google's attempt to build its archive of everything. YouTube is truly vast, and it'll continue to grow. It's arguably the most important tool for speech and entertainment on the internet, and we think it's probably the world's greatest and most transformative teaching and learning tool. But as great as YouTube is, in a lot of ways, it's kind of a mess. When over 300 hours of video are uploaded every minute, 24 hours a day, some of it's not going to be that great. While it's kind of amazing and radically democratic that individual vloggers and makers of cat videos and those videos where they just open the toys and look at them get to publish their videos side by side with huge media companies, some creators are concerned that their creative work is cheapened and becomes just another piece of content that gets lost amidst the junk. And people aren't just uploading their own content. Very often people use the service to share material they didn't create, so for pretty much the entirety of YouTube's 10-year existence, it's been getting sued. In early 2007, Viacom opened the floodgates, served over 100,000 takedown notices, and sued YouTube for $1 billion. Sports leagues, music publishers, and other copyright owners all filed class action suits based on the same theory. YouTube and Google should be held liable for the copyright infringements committed by YouTube users. The issue here was whether YouTube complied with Section 512 of the Copyright Act, which was added in 1998 as part of the Digital Millennium Copyright Act, or DMCA. The DMCA sets up safe harbors to protect internet service providers or ISPs from unreasonable liability. Basically, certain ISPs have to block or remove infringing content that it's aware of or for which it receives a valid notice. DMCA safe harbors protect internet service providers that comply with certain conditions when they're engaged in one of 4 covered activities. The first activity is when they're acting as mere conduits, like the pipes of the internet, for example Comcast, Verizon Fios, or Google Fiber. The second activity is caching content, like Google does. The third activity is hosting user-generated content, like YouTube. And the fourth is acting as an information location tool or search engine, like Google or Bing. The problem is, Congress came up with these categories in 1998, which is like 80 years ago in internet years. The DMCA doesn't fit neatly with new categories of online services, including peer-to-peer sharing, torrents, and cloud storage. The DMCA is due for an upgrade. Let's take a closer look at the notice and takedown provision of the DMCA in the thought bubble. So ISPs don't have to actively monitor for infringement, but they do have to act if they know about infringing content. ISPs know there's infringing content on their system when they receive a takedown notice or when they're independently aware of it, through either actual knowledge or where it's obvious infringing activities are going on. This is called red flag knowledge. Copyright owners and ISPs complain that the notice and takedown system isn't working. Rights holders complain that the system only works for large corporate entities. Individuals and small businesses can't afford to constantly monitor for infringement and send thousands of notices. Also, the DMCA requires that content be taken down only from the specific location or URL identified in the notice. Once infringing content, like Interstellar posted on YouTube, is taken down, it just gets reposted in a different location. Copyright owners call it the whack-a-mole problem. ISPs complain that the volume of takedown notices is overwhelming. Google started keeping track of the takedown notices over the past several years. The number has increased from about 130,000 URLs per week in 2011 to nearly 10 million per week in 2015. Lots of these notices are sent using automated systems, which sometimes leads to erroneously removed content that doesn't and can't take into account the fact that the use might be fair. Also, there is some evidence that the takedown system is being abused as a censorship tool, as in the case where some candidates' political advertisements have been targeted for removal during the days leading up to a campaign, or as in the case of video game companies flagging unfavorable reviews as infringing content. Thanks, Thought Bubble. Now, to get back to the Viacom v. YouTube case, the issue really centered around whether YouTube had knowledge that infringing content was being posted to the site, and whether it induced users to post such content. In 2012, the Second Circuit Court of Appeals held that in order for YouTube to lose its safe harbor protections, it must have knowledge or awareness of specific infringing activity. So although YouTube was probably generally aware that infringing content was being uploaded because of the sheer volume of video being posted and the fact they were being sued by a lot of people who were loudly pointing out that a lot of this content was infringing, Viacom couldn't show that YouTube knew about specific infringing content and ignored it. After yet another appeal, Viacom and YouTube settled the case in March of 2014. One big reason for that settlement may have been YouTube's 2012 development of the Content ID system. With Content ID, YouTube allows certain copyright owners to upload their content into a database of protected material. YouTube scans the uploaded content looking for a match in the database. When there is a match, rights holders can elect to either block or remove the offending material or monetize the video by running ads against it. Though Content ID seems to have slowed all the litigation, it's kind of really upset the YouTube user community. Critics point out that the automated system can censor fair uses of protected content and sometimes unfairly flags certain videos. Others claim that the system doesn't go far enough, arguing that YouTube gamed the DMCA and rapidly evolving market to turn a billion-dollar lawsuit into a lucrative business deal, and that YouTube should be more proactive in ferreting out infringing content. In any case, it appears that Content ID is here to stay into the foreseeable future, and there are probably several settlement agreements that require its existence anyway. For the time being, Content ID will continue to chip away at some YouTubers' incomes, which leads us to the issue of monetizing YouTube videos. It's not an incredibly easy thing to do. The difficulties inherent in generating income on YouTube become more complex when you talk about freebooting, which is the unauthorized copying of online content and rehosting it on another website. Unlike linking, sharing, or embedding the file where the original creator is credited and paid for any views that take place, the freebooted file is actually downloaded and reposted on another site where it generates revenue. Our friend Destin at Smarter Every Day made an excellent video about it that you should watch. Freebooting is kind of interesting. The companies that are hosting these infringing videos have something of a perverse incentive to slow down the DMCA takedown process. The longer the video is up on their site, the more views and revenues it generates. While they're observing the letter of the law and eventually taking the stuff down, it seems a little fishy to me. In any case, the compensation structure of YouTube is often at odds with the incentive structure of copyright law. Authors are granted exclusive rights for a limited time, so they may financially benefit from their creation either through sale of copies or licensing access to the work. But this limited grant of exclusive rights becomes less limited all the time as copyright term is extended and extended further into the future. Speaking of the future, let's wrap things up with a little futurism. We're going to look at a few problems with current intellectual property law, and we're going to talk a bit about what the future might look like. We painted a pretty rosy picture of trademark law, and at its core, it is a consumer protection measure that really does function pretty well. We all have to buy things, but trademark law makes sure we can more easily locate and buy the things we actually want and need. But owners sometimes overreach and abuse the system. Trademarks are everywhere, and for better or worse, they've taken on such a level of importance to our day-to-day lives that it's impossible to Photoshop out every soda bottle or shirt logo in our videos. And by the way, Photoshop is a registered trademark of Adobe Systems Incorporated, not a generic term for digital photo editing. And even if our old friend T Swizzy registers phrases like "this sick beat" and other lines from our songs, it's not that worrisome. Trademark registrations don't give owners the right to dictate how a phrase or mark is used. Trademarks become problematic when owners try to use them to restrain speech, like where a restaurant threatens the author of a bad Yelp review with trademark infringement. So patents are a little more of a mess. A lot of recently issued patents are for inventions that are unoriginal, vague, overbroad, or so unclear that bad actors can easily use them to threaten innovation. For example, patents have been issued to basic technologies like sending and receiving of streaming audio and video over the internet, voice over IP systems, and real-time multiplayer games. And to me, all of these seem like basic building blocks for other products. These bad patents seem to serve no function besides generating license fees and curbing innovation. This is really the case with software patents, where inventions can be as abstract as a single click to purchase a book or the idea of sorting your Facebook friends into groups. Patent trolls or non-practicing entities take advantage of these vague patents by filing vague legal complaints. Even if you've closely read the patent and you know your stuff, it's kind of hard to figure out how you've even infringed the thing. There is patent troll legislation currently pending in the House that would require companies bringing lawsuits to use greater detail in their documents. And there's actually a good chance that this patent troll legislation is going to pass next year. Okay, so we spent a lot of time on copyright in this series because we encounter it so often in our day-to-day lives. It's simply inescapable, and judging from the comments you posted, a lot of you really hate it. Law professor Jane Ginsburg has an idea of how copyright lost it and got a bad name. She attributes it to greed. Corporate greed and consumer greed. Corporate owners trying to increase earnings have lobbied for and gotten more protective legislation that extends the term of copyright and interferes with the development of consumer-friendly copying technologies. Consumers want to share content and get stuff for free, and they feel that any law or enforcement mechanism that gets in the way of what they can do with their own equipment in their own homes is illegitimate, and it's a threat to the public interest. Copyright owners argue that there are now so many creators that strong exclusive rights are the best way to promote the public interest. So one thing I've noticed in the comments is that you guys think copyright term is way too long. Well, there's evidence to back this belief up. Fewer than 11% of copyrights registered between 1883 and 1964 were renewed at the end of their 28-year term, even though renewing didn't cost very much. So back when stuff could move to the public domain, copyright owners let 89% of their works lapse, because the works no longer had any economic value, or the authors just didn't care anymore. In our current system, the copyright term is automatically life plus 70 years with no renewal requirement, but a similar percentage of today's copyright-protected works will likely be neglected and forgotten about within a few decades, or even a few years of their creation. The only difference is that they're still protected by copyright. This creates a huge body of work that's under protection, but where the author or owner often can't be found to grant permission for use. These are called orphan works. Good faith users that want to make use of these works can't find the owner, can't get permission, and therefore face the risk that they'll be sued if the owner does eventually step forward. The Copyright Office has advocated for legislation that will limit liability for good faith users of orphan works who've at least made some attempt to find the owner. This legislation also might create a framework for the private sector to develop rights clearance mechanisms that'll make it easier for creators to use copyrighted work. It's possible that Congress may consider introducing legislation along these lines in the coming years, but you know how Congress is. There are also some really interesting private initiatives that have tried to address the super long copyright term. Organizations like Creative Commons and Copyleft have attempted to let creators choose how their work can be used by others, and these movements have gained some traction. It's hard not to just argue that the term should be shorter, but that's really hard to do. Changing US law requires the revision and maybe renegotiation of all these international treaties that further entrench the life plus 70 term. And the US is signing more of these treaties all the time. So unfortunately, the life plus 70 term is here to stay. So I may have given the impression here that intellectual property law is a stinking cesspool of greed and confusion, but I'm going to argue that there is some value here. The basic notions that individual authors should be rewarded for their creative efforts, that inventors should profit from their inventions, and that manufacturers of goods should be able to market their products without fear that knockoffs will appear on supermarket shelves, these are all good ideas. Maybe you think they're not, but I believe that we as a society can't neglect our creators and innovators. We also can't allow outdated laws to prevent technological innovation and progress. The trick, as always, is striking a balance, a combination of strong exclusive rights for authors and inventors and equally strong and flexible exceptions and limitations that allow for creators to build on work that came before. Is this possible? Reply hazy. Ask again later. Well, there you have it. As usual on CrashCourse, there are no answers, only more questions. Next week, we're going to start looking at questions around the world economy with CrashCourse Economics. Thanks for watching. CrashCourse Intellectual Property is filmed at the Chad and Stacy Imigholtz studio in Indianapolis, Indiana, and it's made by all of these nice workers for hire. If you'd like to keep CrashCourse freely available for everyone forever, you can support the series at Patreon, a crowdfunding platform that allows you to support the content you love. Speaking of Patreon, we'd like to thank all of our supporters in general, and specifically thank our Headmaster of Learning, Thomas Frank, and our Vice Principals, Kathy and Tim Phillip, and Linnea Boyev. You can get awesome material rewards for your support, but I know that's not why you're in this thing. You're in it for the greatest reward of all, which is helping people learn. Thanks for watching. We'll see you next week.